Good morning, sir.
Morning.
For the record, Brendan Miller. We've corresponded before on other files, as you might recall. I'm counsel for Freedom Corp, which is the representatives of the protesters that were in Ottawa in January and February. Nothing to do with the borders, sir. So I just wanted to get out some of the information with respect to the information that you gather internationally and that is given to the CBSA, if you don't mind. So if you can turn your mind to that. So Canada, of course, is a part of what they call the Five Eyes. Can you sort of give an explanation of that for the folks at home?
Well, the Five Eyes is Canada, the United States, Australia, New Zealand, and the United Kingdom, and it's a term that's been used to the Allied relationship since World War II.
Right, and in the Five Eyes group and everything, a lot of the information that is gathered by the Five Eyes is provided to the CBSA for security purposes. Is that fair?
Yes.
Right. And so, and of course, the Five Eyes, the United States, you get information from the agencies in the United States about any sort of threats that may exist both for Canada, but also for the United States. And that's essentially put into the CBSA's information bank, and so that you have it with respect to people coming across the border. Is that fair?
If the information is relevant to the border, yes.
Right. And it's fair to say that throughout the protest, and at least based on the disclosure, the agencies in the United States, such as the FBI, et cetera, they did not provide the CBSA or the Five Eyes any form of information with respect to any threat to Canada. Is that fair?
I wouldn't be aware of that exactly. I think you'd probably better talk to those like Communications Security Establishment and or CSIS to find that out.
Right, but nothing was brought to your attention as the president of the CBSA with respect to any sort of threat to Canada coming from the United States during the protest. Is that fair?
That's correct.
Right, and so of course you never relayed such information to cabinet or to any of the political executive because you weren't given any.
I believe that to be true, yes.
Right, and just to be clear, and I think my friend has made this clear, at no time did you advise cabinet or provide information to cabinet that there existed a Section 2 CSIS Act threat under the CSIS Act. Is that fair?
It wouldn't have been my purview to refer to a CSIS Act threat.
Right. And so is it within, and we keep hearing that, we haven't had CSIS testify yet, all of the law enforcement agencies that have testified to date have said that that purview was solely up to CSIS. Is that your understanding of how it works?
That's correct.
Right. So, and if CSIS is the only agency providing that information, and CSIS says there's no Section 2 Security Act threat, is it fair to say that cabinet would have been never advised of any Section 2 CSIS Act threat?
You'd have to talk to the director of CSIS about that.
When you were present, when you were dealing with the IRG, is it fair to say that no law enforcement agency, no intelligence agency within Canada advised the government that there was a Section 2 CSIS Act threat?
Again, you'd have to talk to the director of CSIS about that.
Right. And during your dealings with the political executive, essentially they have been stating in public that law enforcement agencies advised them that the threshold for invoking the act was met. All right? What law enforcement agency advised them of that to your knowledge?
I'm not aware of who may have provided that advice.
Right. Neither are we. Thank you.
Good morning. I'm Hatem Kir, counsel for the Justice Center for Constitutional Freedoms. The first topic I wanted to ask you about is the power for border agents to turn people away if they were coming to participate in the protest under the Emergencies Act. So you testified that that was one of the powers that was granted to border agents by the emergency regulations?
Yes.
And you were also asked about the ability of border agents to turn away people who are coming for a known unlawful purpose, and they could do that if they knew about that, correct?
Before or after?
Before the emergency measures were.
Well, it wasn't an unlawful protest at that point in time, before the Emergencies Act, right?
Right, but you were asked if you knew someone was if your agents, knew that an individual was coming to enter the country in order to engage in unlawful activity, your agents could turn that person away, correct?
If it was not for a lawful purpose, yes, they can turn somebody around.
Right. And you indicated that one of the problems with that is that your agents would actually have to know that a person is coming for that purpose, which could be difficult, right?
Yes.
Okay. And under the emergency regulations, your agents could turn someone away if they were known to be coming to engage in a certain kind of prohibited public gathering that might breach the peace through listed.
Known or suspected.
Right. So, but your agents would then face the same problem in terms of having to identify a person's intentions, correct?
Well, a standard question for a foreign national is what's the purpose of your visit to the country, right? And so that would just lead you down a line of questioning that the officer then would decide whether or not the person was prohibited from entry or not.
Right. And the same thing would happen if a person's purpose for coming was an unlawful reason, correct?
Yes.
Okay, thank you. And the other topic I wanted to ask you, so you described how the CBSA was able to help facilitate obtaining tow trucks by waiving the requirement for a work permit to enter the country, correct?
A little bit broader than that, but essentially, yes. So basically, with the agreement with the United States for emergency vehicles, where we got many communities that share access to these vehicles to help each other out, is we would facilitate the entry of those vehicles to participate in whatever the event was, notwithstanding the fact that they didn't have a work permit.
Okay, so under the normal circumstances, there's some sort of a regulation, I assume, that requires them to have a work permit?
Well, under the Immigration Refugee Protection Act, you have to have one of the requirements for entry would be a valid work permit.
Right. So, and just trying to understand how that actual process worked, would it fall under the discretion that border agents have when they're enforcing these laws to simply
I believe it's
notify in
just
that
a
instance?
memorandum of understanding that we have with our American counterparts to facilitate emergency vehicles for the purpose of participating in resolving whatever the issue is.
Right. But would I be correct in thinking that that would operate as an exercise of the border agent's discretion to simply not apply what would normally be a requirement for entry into the country?
I don't know that the individual officer would do that. I think that would probably take, it would go a little bit further up the command chain in terms of saying, yes, this is where we're going to invoke this memorandum, for lack of better words, to facilitate the entry of the emergency vehicles.
Okay, but what I'm trying to get at is the operation of law that's happening here. It's a decision not to apply a law that normally exists,
Yes,
right?
so yes, officers have discretion.
Right, okay. Now, we heard yesterday from Deputy Commissioner Curtis Zablocki that one of the things that RCMP tried to do in Coots was to obtain tow trucks from the United States, but some of them couldn't actually come and help because they were unvaccinated. Did the CBSA waive any of the vaccine requirements for tow truck drivers to come and help?
I'm not aware of that.
Okay, those are all my questions. Thank you for answering them.